to today's webinar, Exempt and Non-Exempt Employees, FMLA, Overtime, Travel Time, Leaves, etc., presented by our sponsor, Heffernan. We're super happy you can join us today. My name is Michelle Wilcox, and I will be your moderator. I will also be monitoring questions you may have during the session. Before we open up the session, let's review a couple of key items. All of the webinar materials we discuss can be found at the URL currently showing on your screen. I will also be sharing this URL in a follow-up email, so don't feel like you need to write it down right now. If you have trouble with your internet connection during the webinar, we recommend leaving the presentation and logging back in. We do not control the audio, your devices do. So if you have audio difficulties, try adjusting the volume settings on your device. If a telephone line goes dead during the call, hang up and call back again at the same number. If all lines go dead, watch the on-screen questions box for an alternative call-in number. Please feel free to ask questions or provide feedback by using the questions box during the webinar. If you are using a tablet, you may need to tap on the screen for the options bar to appear. Then you can select the appropriate option. If we can't get to your comment or question during the session, we will be online afterwards to respond, or we may follow up in an email if we run completely out of time. You may also email us at moderator@aspenrmg.com for up to 48 hours after the webinar. This will be a 1-hour presentation. Questions and comments are very much encouraged throughout, and the presenter will be answering questions at the end. And lastly, we have a number of upcoming webinars covering a variety of topics, which you will find on our website. With that, let's begin today's webinar, Exempt and Non-Exempt Employees. Our presenter today is Deb Beto. 16 years ago, Deb founded her company called Your Ops Manager that manages the business operations of small businesses, including all the elements of human resources. As an advisor to companies of less than 50 employees, Deb is advising employers about exempt and non-exempt employees since 2010. And with that, I'm going to go ahead and hand over the presentation to you, Deb.
Thank you, Michelle. Can you see my screen okay?
I sure can.
Great. Well, welcome everyone to today's webinar on exempt versus non-exempt employee classification. As Michelle said, my name is Deb Beto. I am the founder and CEO of Your Ops Manager, and we have a lot of ground to cover today. So I want to make sure we leave time for your questions at the end. So let's just get started. And before we get started, I'll just let you know this year's presentation includes important new guidance from the Department of Labor that was issued on January 5th of 2026. Just this year. So I'm really excited to share it with you, believe it or not. Okay, let's go. I got to start with a legal disclaimer though. Before we dive in, I need to share this. Nothing I say today constitutes legal advice. This is an educational overview. Your specific situation may require consultation with an employment attorney. Okay, everybody got that? Great, let's just move on. A little bit about me. I founded Your Ops Manager in 2010 to help small businesses navigate the complex world of HR and operations compliance. I hold a senior professional in human resources certification through the HRCI Institute, and I've been doing this for over 15 years. Wage and hour compliance, including exempt versus non-exempt classification, is one of the most common and costly areas where I see employers run into trouble. And that's why I enjoy doing this webinar every year. So let's just start with the first polling question.
Okay, so again, thank you everybody for participating in this. So the question is, salaried employees and exempt employees are basically the same thing. A, true, all salaried employees are exempt. B, false, they are concepts. C, it depends on the state. And D, I'm not sure. So I've launched the poll and I'm going to give it a little bit of time to let everybody vote. And again, thank you for participating. We really appreciate it.
And my audio is okay, Michelle?
Yeah, it's a little muffled, but it's okay.
Okay.
Okay, I'm going to close the poll now, and it looks like 65% say false, 10% say it depends on the state, 14% said I'm not sure, and 11% say true.
Okay, good start. Well, the answer is false. salaried and exempt are not synonymous. Exempt employees must meet both a salary basis test and a duties test under the FLSA. You can have a salaried employee who is non-exempt and therefore eligible for overtime. And salaried simply describes how they're paid. Exempt describes which rules apply to them. This is one of the most common misconceptions employers have, and it gets them into trouble all the time. So hopefully we'll learn some things during this webinar today that will keep you out of trouble. So here's our roadmap for today. We'll start with the foundational definitions because I find that many employers and even HR professionals are fuzzy on these concepts. And then we'll talk about the real costs of getting it wrong, which tends to wake people up a little bit. And then we'll work through each of the major exemptions and their tests and cover common pitfalls. And then I'll share some important new guidance from the Department of Labor released just this past January, just 3 months ago. And finally, we'll wrap up with a practical recommendation that you can take back to your organization. We'll have polling questions throughout to keep you engaged. And I love hearing your answers. So let's go. So what does exempt actually mean? It means exempt from the Fair Labor Standards Act, which I refer to as FLSA, and it means that they're exempt from the FLSA overtime and minimum wage provisions. So FLSA defines overtime and minimum wage, but anybody that is exempt does not have to be in compliance with those overtime and minimum wage provisions. Exempt employees are typically classified as executives, administrators, professionals, outside salespeople, or computer professionals. But the key word is typically. The job title alone does not determine exempt status. To be lawfully exempt, an employee must pass all 3 parts of the test. The first one is, number 1, they need to be paid on a salary basis. Number 2, they must meet the minimum salary level. That is 2 times minimum wage, which is currently $684 a week on a federal basis. States are going to be different on that salary level, though. And number 3, they need to be performing duties that satisfy the specific exemption. And all 3 of those tests must be met. If you fail any one, then the employee should be classified as non-exempt, meaning that they're not exempt from earning overtime or minimum wage. Non-exempt is the default classification under federal law. The government would like to presume that every employee is non-exempt unless the employer can affirmatively prove that they qualify for an exemption by passing all 3 of those tests that we just mentioned. Non-exempt employees are entitled to at least the federal minimum wage for all hours worked and overtime pay at 1.5 times their regular rate for any hours over 40 in a work week. That's federal. States have more different rules, and as long as they meet the minimum of the federal rule, the state can set any state rules that they want to. And many of them do. Some of them have more generous rules. California, for example. California requires overtime for hours worked beyond 8 in a day, not just 40 in a week. I have a little frog in my throat today. Employers must comply with whichever standard is more protective of the employee. So in California, you can't choose, I'm going to choose the federal law instead of the California law. No, you have to choose the law that is more protective of the employee, which in this state is California. And remember, the employer bears the burden of proving exempt status. The law doesn't require the employee to prove that they're not exempt. Let's look at some real-world examples. Notice on the right-hand side, supervisor, office manager, administrative assistant. These are not typically exempt positions, and this surprises a lot of employers. Just because someone has a management-sounding title does not make them exempt. The key question is always, what are their primary duties? A working supervisor who spends more than 50% of their time doing the same work as their team is usually non-exempt. An office manager who primarily does clerical and scheduling work does not meet the administrative exemption duties test, and we'll go deeper into each exemption duties test in just a few minutes. First, let's talk about what is at stake financially. Here are 3 significant developments from 2025. First, a Massachusetts employer just paid $3.2 million for the same mistake we've talked about before, classifying inside sales reps, or which we will talk about in a few minutes, classifying sales reps as exempt administrative employees. The Department of Labor found their primary duty was producing sales, not supporting management operations. $3.2 million, for over 700 employees. And this follows the legal theory that if you were on the webinar last year, there was a case that I highlighted that the courts keep ruling the same way and the employers keep making the same mistakes. So once precedent has been set, you better pay attention to how these other cases have settled so that you know what you're doing wrong. Okay, the second one is a Salad Works franchise. This one is still pending, but it's a perfect working manager example. So a franchise classified all assistant managers as exempt. The employees claimed that they spent the majority of their time making sandwiches alongside the hourly staff. So the court refused to dismiss the case. They said the collective action could move forward. So in this case, the collective action is moving forward, and if the classification fails, the employer is going to owe overtime for every assistant manager across all the locations. So the type of work that somebody is doing is very important. The third case, and this one is actually good news for employers. On January 15th, 2025, the U.S. Supreme Court unanimously ruled in EMD Sales versus Carrera that employers only need to prove an exemption by a preponderance of the evidence. So the Fourth Circuit had been requiring clear and convincing evidence, which is a much higher bar, but this lowers the litigation burden for employers. But the burden still falls on you to affirmatively defend every exempt classification. And this ruling makes it easier, just not easy. So we now know that misclassification can be very expensive. So before we get into the specific exemptions, I want to make sure you have the right mindset. There are 4 key principles. The first one, the job title does not determine the exempt status. A manager, quote unquote, who mostly does the same work as their team is probably non-exempt. A senior coordinator who exercises genuine discretion over significant matters may be exempt, even though they don't have the word manager in their title. It's about the work, not the title. The second concept is that non-exempt is the default. You must be able to prove that the exemption applies. The third concept, important to grasp, both tests must be met, salary and duties. Meeting one is not enough. And the fourth test, if you're doing a classification audit, which I highly recommend, seriously consider doing it under the direction of an employment attorney. This can protect the audit documents under attorney-client privilege, which is valuable if you face later litigation. And I can't stress enough how important that attorney-client privilege is in HR cases. Anytime you need to do any type of investigation into your HR practices, I would highly recommend using an attorney so that you have that attorney-client privilege. Okay, let's talk numbers. The salary test requires that exempt employees receive a minimum salary that meets or exceeds the threshold. So the federal right now is $684 per week, or $35,568 per year. And here's an important update. The Biden administration tried to raise this to $1,128 a week, effective January 1st, 2025, but a federal judge in Texas struck that rule down in November of 2024. So we're back to the $684 a week level that's been in place since 2019. The DOL has indicated that it may revisit this through the regulatory process, so stay tuned on that front. But the states are all different, and I'm just going to use California as an example, just because I know that a lot of people in this room are from California, but if you're from a different state, you might want to research that state as well. So California is much higher. As of January 1st, 2026, California employers must pay at least $1,352 per week, even higher than Joe Biden wanted. That's $70,304 per year. And that's for exemptions, for exempt employees. California's formula is 2 times the state minimum wage multiplied by 2,080 hours, because 2080 is a magic number in payroll terms. If you take 8 hours a day multiplied by 5 days a week, multiplied by 52 weeks a year, you come up with 2,080 working hours a year. So California's minimum wage went to $16.90 an hour on January 1st, 2026. So now we are at $70,304 per year. There's 2 critical rules that you need to understand. Number 1, you cannot prorate. It must be the full weekly salary that has to be paid, even if the employee works only a few hours. And number 2, docking pay for absences generally defeats the salary basis requirement, which voids the exemption entirely. They're either paid for the week or not paid for the week. If they're paid for the week, they're exempt, even if they only work 1 hour. If they get paid for the 1 hour, then they're not exempt, and they should be earning overtime and at least minimum wage. Okay, we have another polling question, and I'm going to let you know this is kind of a tricky one.
Okay, so an employee earns $40,000 a year but manages a team of 5. Are they likely exempt under the executive exemption? The options are yes, they manage people. No, they don't meet the federal salary text. It depends on their duties. And yes, if they have hire and fire authorities. So I launched that poll, and I'm sorry, that's supposed to be a test. That's my fault. So give it a second here. It's like, that doesn't make sense. Okay. Thank you again for participating. And I'm going to go ahead and close it once it gets, we got 60%. So let's go back here. So we've got 53% says it depends on their duties. 31% say no, they don't meet salary test. 8% says if they have hire and fire authority, and the other remaining says they manage people.
All righty. So this was, like I said, sort of a tricky question. At $40,000 a year, which is $769 a week, they do meet the current federal salary test of $684 a week. But if they're in California, which is the $769 a week is below California's threshold. Also, they must still meet the duties test for the executive exemption. This person manages 2 or more, they must manage 2 or more full-time employees, have hiring and firing authority, and 50% exempt duties. The salary test alone does not make them exempt, but both tests must be met. So this one was a little tricky. And it's different whether you're thinking of any state or if you're thinking of California. So it's in California, no, they don't meet the California test, but they do meet the federal test. Okay, so let's go to our next topic here, discretion and independent judgment. Discretion and independent judgment. It's a concept that runs through almost every white-collar exemption. The regulation says the employee must customarily and regularly exercise discretion and independent judgment. What does this mean in practice? So the employee must genuinely compare options and make independent choices on matters that matter. They can't be micromanaged or simply follow a checklist. What does not qualify is an employee who follows a detailed script, applies established procedures, or simply recommends a decision that their supervisor always makes. That is not discretion and independent judgment under the FLSA. And this is often the tripping point for working managers, which we'll discuss next. The working manager is one of the most common misclassification problems I see. Employers often make someone a manager and then pay them a salary and assume they're exempt, but the key is what they spend most of their time doing. Under the executive exemption, the employee's primary duty must be managing. If they spend 60% of their time doing the same work as the people they supervise, then their primary duty is not management, it's the line work. And the SolidWorks franchise case that we saw earlier is a perfect example. The class of employees were called assistant managers, but their primary duty was making sandwiches. The court saw through the title. So when you have working managers, document very carefully what percentage of their time is spent on management versus line duties, and whether they genuinely have higher fire authority or if they just make the recommendations. Now let's go through each of the 6 main white-collar exemptions under the FLSA. Remember, all of them require meeting the salary test first. If the salary isn't met, then the analysis stops there. The employee is not exempt. Once the salary test is met, then we can go on to the different types of exemptions. We have the executive, the administrative, professional, which has 3 subcategories, outside sales, commissioned inside sales, and computer professional. So let's go through them one by one. The executive exemption is for employees whose primary duty is genuinely managing a business or a recognized department. The key requirements is that they must manage at least 2 full-time employees, and this means the equivalent of 2 full-time positions. It's okay if they manage multiple part-timers that add up, but they must have a real authority to hire and fire, or at least make recommendations that are given particular weight and are routinely followed. And don't forget the 50% rule. Management must be their primary duty. This doesn't mean they can never do line work, but when they're called away from management to do the work themselves, you need to document that. Courts look at the whole picture. And remember, an exempt employee under the executive exemption who does managerial duties is still entitled to their full weekly salary, even in the weeks where they do minimal work. So they work for an hour, they're off skiing in Switzerland, they are checking their email for an hour a day. Guess what? No PTO. It's all exempt status. Okay, the administrative exemption is the most commonly used and the most commonly misapplied exemption. So the key is the concept of staff versus line work. Administrative exempt employees support the business operations. They don't produce the company's product or service directly. Think HR manager, finance manager, or a corporate compliance officer. They advise, plan, analyze, and guide, but they're not on the assembly line or making sales calls. The Massachusetts company that we saw in the news section is a perfect example of what doesn't qualify. Employees whose primary job was sales, that's producing the company's business, not supporting its management functions. The discretion and independent judgment required is critical here. An employee who follows detailed scripts, processes routine paperwork, or applies established procedures without genuine decision-making authority is not exercising discretion and independent judgment as the FLSA requires. The professional exemption has 3 subcategories: learned, licensed, and artistic. So let's break them down. Learned is the most common. It requires advanced knowledge, typically a bachelor's degree or higher, in a field of science or learning. The work must be predominantly intellectual and require the application of that knowledge. So think about a pharmacist, an engineer, or a CPA. Those types of positions would typically qualify. Licensed is a category that covers certain professions that require a specific license. Think about doctors and lawyers and teachers. They don't have minimum salary requirements. They qualify for the exemption regardless of pay, as long as they meet the duties test. But not every licensed profession qualifies. The license must be for one of the recognized fields listed in the FLSA regulations. The artistic exemption is one for creative fields where the work depends on invention, imagination, and maybe talent that cannot be mass produced. A musician who writes original compositions might qualify for this. But a musician who just plays the same set list every night, that's a much harder argument. So what's very important is that the professional exemption also requires meeting the salary test, except for the 3 no minimum salary professions: lawyers, doctors, and teachers. All right. These are the professional exemption traps that get healthcare and other employers in trouble. Nurses. Registered nurses are generally not exempt if they're paid hourly, even though they have tremendous clinical responsibility. The Department of Labor's January 2026 opinion letter that we'll discuss shortly reinforces this. Changing a clinical social worker from her salary to hourly defeated the exemption, even though the duties still qualified. We'll talk about that in just a minute. Pharmacists. A pharmacist typically qualifies as a learned professional because they need an advanced pharmacy degree. But if you pay them hourly, you've eliminated the salary basis requirement and the exemption doesn't apply. So just pay your pharmacist a salary. Physicians is an interesting case. The learned professional exemption for doctors has no salary minimum, but that doesn't mean paying a doctor hourly makes them automatically non-exempt. It depends on the totality of the compensation arrangement and duties, and this really requires some legal analysis. So these are the 3 exemptions to watch out for. If this is typical in any of your organizations, you may want to just run your scenarios by an attorney so that you have attorney-client privilege and make sure that you are well within the FLSA standards. So let's move on to the outside sales exemption. This is fairly straightforward, but frequently misapplied in the post-COVID world of remote work. The key requirement for outside sales is that the employee must spend more than half of their time away from the employer's place of business, making sales or obtaining orders at the customer's or prospect location, not their home office. Selling via Zoom, phone, or email, even if the employee is calling on customers, does not count as outside sales under the FLSA. They must physically be at the customer's location. And this has become a significant issue since COVID, when many outside sales reps shifted to inside and virtual selling. What's really important to remember is that this exemption has no minimum salary requirement. An outside sales rep can earn pure commission and still be exempt as long as they meet the 51% threshold of being out of the office. There are nuances around setup time, delivery time, and return travel, and these vary between federal and state rules. So again, you might be in a better position to consult with your counsel if this situation applies to your company. So that's outside. Now, how about inside? Commissioned inside sales exemption under Section 7I is frequently misunderstood. First, it only exempts from overtime, not minimum wage. The employee still gets minimum wage for all the hours they worked. Second, the business must be a retail or service establishment. Manufacturing companies and wholesalers don't qualify. So this is a true inside sales position in a retail organization. Third, regarding the minimum pay test, this is directly addressed in one of the January 2026 DOL opinion letters. And the DOL clarified that the minimum pay standard of $10.875 per hour is based on 1.5 times the federal minimum wage, not the state minimum wage. So even if your state's minimum wage is $16 an hour, you only need to pay $10.875 per hour to satisfy this test, although you must still comply with the state minimum wage separately. So it makes it very confusing. Fourth, commissions must exceed 50% of total pay, and they must be paid at least each period, not deferred. The computer professional exemption applies to software engineers, systems analysts, and programmers, but not to everyone in an IT department. In California, this exemption has a very high salary threshold in the state. As of 2026, the employee must earn at least $115,763.35 per year, or $55.58 per hour. And this updates annually. In California, even an exempt computer professional can still be entitled to overtime. So this requires careful analysis. A key distinction is that an employee who uses software to do their job is not a computer professional under this exemption. The exemption is for people who design, develop, or create computer systems and programs. So just because somebody uses a computer does not make them a computer professional exempt person. They actually have to design, develop, or create computer systems to be salary exempt. A help desk employee, for example, uses computers. They troubleshoot computer printer problems. They reset passwords. This is not a computer professional. A software engineer who writes the code to build a new application is the computer professional. So, good time for a polling question. I'm losing my place.
All right. So the next question is, your IT help desk manager earns $75,000 a year, oversees a team of 3. Are they exempt under the computer professional exemption? Your options are yes, they are IT and earn over the threshold. B, no, managing IT doesn't mean designing software. C, depends on their duties. Or D, yes, if they also code sometimes. And I'll give it a second here. And again, thank you, everybody. And I'll go ahead and I'd like to wait until we're at least 50% or 60. So I'll give it just one more second. Okay, and I'm going to close the poll. It looks like 44% say no, managing IT doesn't mean designing software. 42% says dependent on their duties. 14% says yes, they're in IT and earn over the threshold. And 1% says yes, if they code sometimes.
All right. Well, I'm going to give credit to anybody that gave answer B or C, because the computer professional exemption requires that the primary duty be designing, developing, or analyzing systems, not managing people or troubleshooting routine issues. So they would not qualify under the professional exemption, but this manager might qualify under the executive exemption instead if they manage 2 or more full-time employees. So that's where C, depends on their duties. So if it meets the duties test, they may qualify under the executive exemption, but just being in IT and earning over $684 a week does not make someone a computer professional exempt employee. Okay. The cost of misclassification. This is one of the most important slides in the whole presentation. If you classify a non-exempt employee as exempt, and remember that the government standards presume that every employee is non-exempt. So if you classify a non-exempt employee as exempt, you are in trouble, big trouble. The law presumes all employees are non-exempt. You've been paying them a salary and telling them they're exempt, meaning they haven't tracked their hours and you haven't tracked their overtime, and you could owe years of unpaid overtime. If you are found to have acted willfully, the statute of limitations extends to 3 years and you owe liquidated damages. That doubles everything. Then add attorney's fees on top of that. It's a very expensive misclassification. If you classify an exempt employee as non-exempt, there is no FLSA violation. No violation whatsoever. And the January 2026 UL opinion letter that I'm going to share with you in a minute confirms this explicitly. It says the FLSA only prohibits misclassifying non-exempt employees as exempt. An employer has the right to classify anyone as non-exempt and pay them overtime. It may cost you more, but it's legal and it's safe. So let's run through some of the most common FLSA pitfalls that I see. The first pitfall is comp time. I can't stress this enough. Private employers cannot offer comp time instead of overtime pay, period. This is one of the most common violations I see, especially in small businesses where it feels like a nice arrangement for everyone. It's not legal. And a lot of times the employee will be the one that wants to do that. The employee will say, hey, can I take Friday off if I work an extra 2 hours Monday through Thursday? And the employee wants to do that for their own benefit, and they're trying not to put the employer out of the overtime, and they're trying to do the right thing, and what it's doing is causing long-term situations. So if another employee complains about not getting overtime and the DOL or the EDD comes in to do an audit of all of your payroll records, they're going to see that you made these kind of side arrangements, and that's just going to prove that you willfully did not comply with the overtime laws, even though that employee thought that they were doing something to your benefit. So just don't offer comp time instead of overtime pay, period. The second pitfall, docking exempt pay. If you have an exempt salaried employee and you dock their pay for a partial day absence, you may have just converted them to non-exempt. And the salary basis requirement is strict. You can make deductions in full day increments under certain circumstances like PTO requests or leave of absence, but partial day docking is almost always impermissible. The regular rate, this is the one that surprises employers. When you calculate overtime, you can't just use the base hourly rate. The regular rate must include most bonus payments, also shift differentials and commissions. The January 2026 DOL guidance on bonuses is directly relevant here. Non-discretionary bonuses must be included in the regular rate of calculation. Off the clock, if a non-exempt employee checks Slack messages on their phone after hours, and I'm referring to business Slack messages, or they might respond to a work email, or they might boot up their computer before clocking in, that is compensable time for non-exempt employees. There's some other examples on this slide, and Michelle will be sending out these slides so you can kind of get a gist of what might apply to your company. But I need to save some time here, so I'm going to move ahead to the next slide. This is the section I'm most excited for in this year's presentation. We finally have something new to explain. On January 5th of 2026, the Department of Labor's Wage and Hours Division issued 6 new opinion letters. 4 of them are under the FLSA and 2 under the FMLA. So what's an opinion letter? It's an official written interpretation by the administrator of the Wage and Hour Division of how federal employment laws specifically apply to specific situations. Opinion letters are not law, but they do carry significant weight. They really try to clarify the law. Employers who rely in good faith on an opinion letter and later face litigation may be able to use the letter as a defense against finding of a willful violation. So let's go through the 4 FLSA letters, and these are the ones that are most relevant to today's topic. FLSA 2026-1 is particularly important for HR professionals and employers doing classification audits. The key holding is that an employer can voluntarily choose to classify as non-exempt, even if the employee meets all the criteria for an exemption. And this was already generally understood as an acceptable concept, but the Department of Labor's confirmation in writing is very helpful. And if you've been wondering whether you can reclassify a borderline exempt position as non-exempt to reduce your litigation risk or your wage and hour risks, the answer is yes. You will pay overtime, but you won't face an FLSA violation. But it's also important to remember that all three tests must be met if you're going to in other words, if the duties test and salary level test are satisfied, switching to hourly pay eliminates the salary basis requirement, which voids the exemption. So the situations that apply to whether you're going to choose exempt or non-exempt the tests still have to be met. And this is also a good reminder: when you're restructuring and you eliminate the supervisory duties, you should reevaluate the classification. Don't just assume the employee remains exempt. Okay, FLSA 2026-2 addresses bonus calculations for overtime purposes, and it's a common area of non-compliance. The Department of Labor confirmed that the Waste Management Company's safety and performance bonus was non-discretionary, meaning it must be included in the regular rate of pay when calculating overtime. Why? Because the bonus was based on a predetermined formula. Once the employee met the criteria, they automatically earned the bonus. The employer had no discretion to deny a qualifying employee their bonus. And there's a practical impact of this. If your company has performance-based bonuses or attendance bonuses or safety bonuses with very defined criteria, those bonuses must be included in the regular rate of pay when calculating overtime for non-exempt employees. So how do you include them? You divide the bonus amount by the total hours worked in the period the bonus was earned, and then you add that amount to the employer's regular hourly rate and pay 0.5 times that added amount for each overtime hour in that period. And this is an area I recommend every employer review carefully with their payroll team. If you do not have your bonuses defined as either discretionary or non-discretionary, and what causes it to be discretionary, then you could be facing some heavy penalties for not calculating overtime correctly on your employees' paychecks. Two more Department of Labor opinion letters that employers should know about. The FLSA 2026-3 on roll call time. This is particularly important for employers with any type of mandatory pre-shift activities. If you require employees to show up for anything before the official start of their trip, of their shift, then let's say maybe a briefing or equipment checks or putting on their uniforms, and that requirement is established by contract, custom, or practice, it is compensable time. It must be tracked and counted towards overtime. The Portal Act generally excludes preliminary activities, but only if they're not made compensable by contract or custom. And this had to do with a fire department that was actually required to show up for roll call 15 minutes early every day. So that's where that opinion letter came in. Okay, FLSA 2026-4 on commission sales. This provides clarity for California employers specifically. Many California employers assumed they had to use California's minimum wage for the 7I pay test, which would make it harder to claim the exemption. The Department of Labor said, no, use the federal minimum wage for this calculation, but, and I want to be clear, you still must pay at least the state minimum wage in California. So the 7I test just uses the federal number, but you still need to pay the California minimum wage. Talk about confusing, right? That's why these opinion letters come out, to try to clarify the confusion. Okay, let's move on to another polling question.
Here we go. All right. So your company gives all employees a quarterly performance bonus if they meet their goals. Do you need to include this in overtime calculations? The options are A, no, it's called a bonus and it's discretionary. B, yes, performance criteria make it non-discretionary. C, if the bonus exceeds 10% of their pay. Or D, no, we only pay it quarterly, not weekly. So I will give it as just a second here. And we got a lot of questions. So I just want to remind everybody that if we run out of time during the Q&A at the end, I will be taking all your questions that didn't get answered and I'll send them to Deb for her response and then email them to you individually. So I just wanted to let everybody know that because we do have it's a lot of information,
I know,
a lot of questions.
this is such a confusing topic. I know we always get tons of questions on this one, on this webinar.
Okay, so
It doesn't help that
like
federal and state are not nice to each other.
right.
Okay, Michelle, go ahead.
So it looks like 73% say yes, performance critical makes it non-discretionary. The next is 23% say no, it's called a bonus, so it's not discretionary. 4% say only if the bonus exceeds 10% of their pay, and 0% said zero.
Can you go back? A is, on my screen, A is discretionary, B is non-discretionary, but you read them backwards.
Oh, I'm sorry. Yes, you're correct. So 73% say it's non-discretionary. I'm sorry.
Okay.
Confusion.
Okay. And how many said A?
So 23% said A, 73 majority said B, and then 4% said C.
Okay, great. So congratulations, the answer is B. The name bonus is irrelevant. What matters is whether there are predetermined criteria that, when met, automatically trigger the bonus. If the employee knows in advance what they need to do to earn the bonus, it is non-discretionary, regardless of what you call it or how often you pay it. And per FLSA 2026-2, this type of bonus must be included in the regular rate of pay for overtime calculations. How you retroactively include it is that you add the bonus divided by the total hours in the period to the hourly rate, and then pay 0.5 times that for each overtime hour. So good job, everyone, getting that right. One of the most common accidental violations for employers who have correctly classified exempt employees is impermissible salary deductions. So your exempt employee has met all of the salary tests and is indeed a salaried and exempt employee, has met all the exemption tests, but you make some salary deductions. That is going to cost you. The key rule is an exempt employee must receive their full salary for any work week in which they perform any work, regardless of the number of days or hours worked. If an exempt employee comes in for 1 hour on a Monday and then gets sick, they get the full week's salary. The impermissible deductions on the left-hand side are the most common traps. So docking an exempt employee's pay because they only worked 3 days or because the office was slow and you sent them home early, these destroy the salary basis requirement. If you have been making impermissible deductions, the employee's exemption may be voided retroactively for the period during which the deductions occurred. There's a window of correction provision under the Department of Labor regulations. And if you have an isolated or inadvertent deduction and you reimburse it, you may be able to preserve the exemption, but this requires careful analysis and, again, maybe attorney-client privilege. So let me close with some concrete recommendations you can take back to your organizations. Number one, do a formal review of all exempt positions, not just the salary. Also the duties. If you haven't reviewed them since you first classified the positions, they may have changed. A secretary who gradually took on more and more responsibilities may now qualify as exempt, but an executive who gradually handed off management duties may no longer qualify. Be conservative. When it's a close call, lean towards non-exempt. Yes, you'll pay overtime, but it is far cheaper than the alternative. Number 3, job descriptions. These are your proof. If you ever face an audit or lawsuit, your job descriptions are Exhibit A. They need to accurately describe what employees actually do. Keep them updated. And I've said this over and over, attorneys, seriously, get legal counsel involved, especially for borderline positions. Do this under the privilege protection. Train your managers. This is critical. Many FLSA violations happen because well-meaning managers don't know the rules. And lastly, bonus review, what we just talked about. In light of the FLSA 2026-2, review your bonus plans to confirm you're correctly including non-discretionary bonuses in overtime calculations. I think we have our last polling question coming up. Michelle, you there?
Yes,
Uh-oh.
I'm sorry. Yes, I'm
Okay.
here. Which of these is the safest approach when you're unsure whether a position qualifies as exempt? A, classify as exempt and document your reasoning. B, classify as non-exempt and pay your overtime. C, pay a salary but don't designate either way. Or D, ask the employee what they prefer. And sorry about that, I was on mute and didn't realize. So give it a second here. And
We've all done.
yeah. Okay, it looks like majority says 93. Answer is B, classified as non-exempt and pay overtime.
Awesome. The answer is B. When in doubt, go non-exempt. You cannot violate the FLSA by being too generous. Paying overtime to an employee who might have been exempt is legal. Classifying a non-exempt employee as exempt is a potential FLSA violation. Also, C, if anybody answered C, that does not work. Paid a salary but no designation is not a valid classification. Every employee must be correctly classified as exempt or non-exempt. And D, what the employee prefers doesn't determine their classification. The FLSA tests are objective. And I will tell you that letter D gets us in trouble a lot because there are a lot of people out there that think that if they have a salary and they're exempt, that their resume looks better. And so they would prefer, they feel like having an hourly rate where they're getting an overtime rate of pay makes them a low wage worker, which may or may not be true, but it would be their preference to be salary exempt for their own status reasons, and that's just not legal. We can't ask the employee what they prefer. So I just want to, get everybody out of that pitfall very early on here. Let's not do that. Okay, let's pull this all together. 8 things that I want you to leave today knowing. 1 through 4 are the foundational concepts, and these are the things that keep employers out of trouble. 5 through 8 are the new 2026 DOL guidelines. So print these out, share them with your payroll team, your HR team, your employment attorney. The golden rule is at the bottom. When in doubt, go non-exempt. Document everything and get legal counsel involved. I say it every year because every year I see clients who did not follow this rule, and it cost them far more than it would have cost to get it right the first time. And right before we get to questions, I just want to mention that Michelle will be sending out a copy of this presentation after the webinar today. So I want to point you to some key resources. The DOL's Wage and Hour Division website has extensive free resources. They have fact sheets, field assistance bulletins, and the opinion letters that we discussed today. And all 4 of the January 2026 opinion letters are publicly available on the DOL's opinion letters page. I encourage you to read them directly. For California employers, the DLSE, which is the Division of Labor Standards Enforcement, is the state equivalent of the federal FLSA. And the industrial wage orders, particularly wage order number 4 and number 7, govern many California commission sales situations. So commission sales seems to be a very confusing topic here in California. So pay particular attention to the IWC wage orders 4 and 7 in that case. And of course, if you'd like to work with us at Your Ops Manager on a classification audit or HR compliance review, please reach out. We'd love to help. And I will open it up for questions. We have 5 minutes. I was hoping for 10, but we got 5 minutes.
Well, it was a lot of information. It was very helpful, but there's a lot of questions. So I'm going to throw out a couple. Are there any instances in which an exempt employee would not meet the minimum wage compliance? The very fact that there's a salary test, which in California is twice the state minimum wage per hour, would suggest otherwise.
I'm sorry. Can you read the question again? I'm not quite understanding just the first part.
Are there any instances in which an exempt employee would not meet the minimum wage compliance?
Yeah, if you're not paying them 2 times minimum wage. So there are plenty of situations where maybe I'm misunderstanding the question. Maybe what they're saying is there a way that you can pay California exempt employees less than 2 times minimum wage? Are there any exceptions to that?
Okay.
And I think that's what they're asking. Why don't we handle that one in an email, Michelle? Yeah.
That sounds great. Okay, the next one, what is the recommendation for providing preponderance of evidence? Should we maintain documentation at the exemption checklist? I think you already touched on that.
That's a great idea, but also the job description is going to be your number one thing. So if you keep your job descriptions updated, your and then documenting how much of the time is spent on managerial exemption work, and making sure that it's more than 50% of the time. They can do line work, but at least 51% of their work needs to be on the managerial exemption status.
Great.
So document that. Document that.
I thought this
There's
was
your preponderance of evidence.
There you go. I thought this was a good question. If a software engineer uses AI to write all their code, does that change the category?
We have yet to see that land in the courts, but that's an excellent question because I do anticipate that. They may come under the artistic, is what I'm going to be guessing. This is purely speculation on my part, but they're still having to come up with the ideas for the work that the AI is generating. But I think we will see sooner rather than later some precedent set in some court cases. So I think you could be right.
Yeah, I thought it was a good question too. Okay, so the next question is, we have 2 exempt salary staff that have supervisor who have justified their ability to have a second job, and they start very early and put in 8 hours. Okay, I need more information. Sorry about that.
Yeah, we can do that one
circle
separately.
Yes.
It sounds very specific, so we can do that one separately.
Yes, it does. Sorry. If you take away someone's exempt, this is also a good question. If you take away someone's exempt status, do you have to give them anything for taking away what they may perceive as a benefit?
No, because there is no benefit. There is no perceived benefit for being exempt. The benefit is in being non-exempt and having the ability to earn overtime. The only thing that you might need to consider is justifying why you took away the exempt status, because if you took away the exempt status because they were misclassified, then you may need to go back and pay them overtime for all of the hours that they should have earned overtime.
Gotcha. All right. Well, we've run out of time right now. And again, thank you all for attending today's webinar presented by Heffernan. We will send an information by email with instructions on how to access a copy of the presentation on our website. Thank you, Deb, for your time and expertise today. We hope all the attendees found today's webinar to be a valuable use in your time. Be sure to join us on April 21st for our OSHA date webinar. And again, just a reminder, we'll go ahead and get to the questions that we didn't get to in a follow-up email. So thank you all, and thank you, Deb. Appreciate it. Everybody have a great and safe day.
Thank you, Michelle, and thank you everyone for attending. I'll look forward to hearing your questions and sending out my answers.